Good afternoon. Thank you all for joining us today to commemorate the 50th anniversary of Title IX. We've got a great panel of speakers here to address this landmark law, to celebrate all that Title IX has done to promote gender equity in education, and to discuss what the future holds for Title IX enforcement. Things have come a long way since the pre-Title IX era. As we sit here today, it might be difficult to imagine a female high school student with stellar credentials, straight A's, president of her student body, applying to her top choice university and being denied because, as the university put it, quote, "women need not apply." And yet that was precisely Marvella Hearn's experience as a high school student in the early 50s. State law at that time banned women from attending Marvella's top choice university. She'd go on to graduate from a different university and marry the future Senator Birch Bayh. And her experience played such a formative role in shaping Senator Bayh's legislative priorities during his tenure in Congress. This includes legislation that Senator Bayh, along with Representative Edith Green, and Representative Patsy Mink, the first woman of color to serve in the House of Representatives, co-sponsored legislation that eventually would go on to become known simply as Title IX after its passage in 1972. Senator Bayh, along with Representatives Mink and Green, fought hard to get Title IX passed, but he was realistic about its limits. He explained that Title IX, quote, "is not a panacea. It is, however, an important first step in the effort to provide for the women of America something that is rightfully theirs, an equal chance to attend the schools of their choice, to develop the skills they want, and to apply those skills with the knowledge that they will have a fair chance to secure the jobs of their choice with equal pay for equal work," end quote. And what an important first step it was. Title IX's impact on gender equity in education was immediate. In 1971, the year before Title IX was passed, there was almost 1.5 million more men than women attending degree-granting post-secondary institutions. But by the end of the decade, that gap had been eliminated. Reinforcing the power of Title IX as a tool to promote gender equity, the Supreme Court in two pivotal cases in the late 90s recognized that sexual harassment and sexual assault are also forms of sex discrimination prohibited by Title IX. And exactly 2 years ago to the day, the Supreme Court held in its landmark decision in Bostock versus Clayton County that sex discrimination under Title VII of the Civil Rights Act of 1964 encompasses discrimination on the basis of sexual orientation and transgender status. Following the Bostock ruling, our very own Pam Carlin, the Civil Rights Division's Principal Deputy Assistant Attorney General, issued a memorandum to all federal civil rights offices and general counsels addressing the application of Bostock to Title IX and determining that Title IX's prohibition on discrimination on the basis of sex includes discrimination on the basis of gender identity and sexual orientation. I would be remiss if I did not mention what Title IX is perhaps best known for: the advancement of women and girls' opportunities in school sports. The year Title IX was enacted, there were fewer than 300,000 girls participating in high school athletic programs. But this number has now grown more than tenfold, with over 3.5 million girls participating in high school sports last year. The Department of Justice has played a key role in enforcing Title IX in K-12 schools and post-secondary institutions that receive DOJ funding. Several sections in DOJ's Civil Rights Division help to enforce Title IX. There's our Federal Coordination and Compliance section, which promotes Title IX compliance through its coordination role with other agencies. There's our appellate section, which litigates Title IX appellate cases. And of course, there's our educational opportunities section, which carries out this important work through all of its Title IX enforcement activities. The Department of Justice remains firmly committed to achieving gender equity in education through its Title IX enforcement work. And we are committed to working collaboratively with our partners in the public and private bar in pursuit of that goal. I want to thank all of our panelists who are here, the Civil Rights Division, our interagency partners, and our stakeholder partners for doing this important work. I'm now going to turn the floor over to one of the Educational Opportunities Section's Deputy Chiefs, Amanda Dallo. Amanda will be introducing the four wonderful panelists who have joined us today to discuss the past, the present, and future of gender equity in education. Thank you all.
Hello, everyone. My name is Amanda Dallo, and as Assistant Attorney General Clarke mentioned, I am a Deputy Chief in the Educational Opportunities section. Thank you all for joining the Department of Justice as we commemorate the 50th anniversary of Title IX with a panel discussion on the past, present, and future of gender equity in education. I am pleased to introduce our panelists for today's discussion. Ria Tabacco Mar is the director of the ACLU's Women's Rights Project. Good afternoon, Ria. Our second panelist is Nic Oke. Nic is a student advocate who serves as a member of GLSEN's National Student Council and the chair of GLSEN's Policy Projects Committee. Hello, Nic. Next, we have Shiwali Patel, the Director of Justice for Student Survivors at the National Women's Law Center. Good to see you, Shiwali. And last, but certainly not least, the Civil Rights Division's very own Shaheena Simons, the Chief of the Educational Opportunities Section. Welcome, Shaheena. Thank you all so much for joining us. Before we dive into the discussion, I want to let the audience know that we are reserving time for the panel to take audience questions. If you have a question, please use the Q&A feature in Zoom to send it in, and we will try to get to as many questions as we can later in the program. Panelists, with that little bit of housekeeping done, you're in the hot seat now. I want to start by giving the audience a little bit of insight into each of you and your own past and present. Can each of you tell us what led you to work on Title IX issues and how your current work relates to Title IX? And Shiwali, I'll start with you.
First, thank you so much for inviting me to speak on this panel with such amazing activists and advocates and colleagues. And I feel very grateful to be here today and to be part of DOJ's celebration of Title IX. And so I guess I've always been interested in issues of gender equity, just more generally, and also in education. I was a campus activist myself a couple of decades ago before enforcement on sexual harassment increased under Title IX. And when I was in college, we were dealing with the same issues then, 2 decades ago, that we're dealing with today, even though there has been more awareness and enforcement in Title IX. So then, we were seeing students being pushed out of school after experiencing sexual violence because they were being punished for violating another code of conduct. Maybe they're intoxicated at the time, right? Or the school was not having enough supportive measures for students, and we were advocating for that. And today I work at the National Women's Law Center in education issues. And NWLC was actually founded the same year that Title IX was enacted, 50 years ago. And since then, we've been advocating for robust Title IX protections for students. So my work today is just a small piece of the history that we have in this. And I lead our work through litigation, representing students, or in filing amicus briefs and advocating for strong federal policy, addressing sex-based harassment in schools, and also working on addressing protections for LGBTQI+ students.
Thanks, Shiwali. Nic, would you like to go next?
Of course. Hello, everyone. As stated before, my name is Nic Oke, and I'm a student advocate from Baltimore, Maryland. Essentially, I came to work on Title IX issues due to my own experiences as an LGBTQ+ student. I've been in the American public education system for the entirety of my educational experience. And through this experience, I've had to endure much discrimination, harassment, intimidation, and bullying for both my sexuality and my gender identity. This is why it's important to incorporate student voices in discussions of Title IX and its applications, and I hope this tradition will continue forward. It's important also that gender identity-based discrimination and sexuality-based identity discrimination are incorporated in our understandings of gender inequity and sexism, as it is impossible to discriminate against somebody on the basis of their sexuality or gender identity without discriminating against them based on a preconceived notion of how people of the traditional sexes should act. In order to further this work, through my role on the GLSEN National Student Council and as chair of policy projects, I've engaged in a variety of events that involve legislative advocacy for more comprehensive non-discrimination protections of LGBTQIA+ communities. Earlier this year, I had the opportunity to work with another National Student Council member advocating for the Safe Schools Improvement Act, which would establish more comprehensive protections for the enumeration of certain categories of marginalized people based on categories such as gender identity and sexual orientation, as well as implement evidence-based practices to measure and reduce bullying within our nation's schools. Furthermore, I participated this year in GLSEN's Day of Silence, an annual day-long event to promote awareness and advocacy surrounding issues involving discrimination, harassment, intimidation, and bullying of LGBTQIA+ students in America's education system. Through this work, I've hoped to advance the promise of Title IX, which has not yet been fulfilled when we still live in a society where systemic queerphobia and transphobia are rampant.
Thank you, Nic. Ria, let's turn to you.
Thank you so much, Amanda, and thank you to the department for hosting this really important conversation. Like Shaheena, I think I've always had an interest in gender justice issues, and certainly when I was on campus as a student myself was involved in our campus, what was then called the BGLTSA. We keep adding initials and in efforts to address the university's inadequate response to campus sexual violence. But as an attorney, the first Title IX cases that I litigated myself actually came not during my time in the ACLU's Women's Rights Project, but during my time as a staff lawyer in the ACLU's LGBTQ and HIV project, where we began to work on cases in which cisgender students had attempted to weaponize Title IX in order to exclude transgender students from bathrooms and other common spaces at school on the theory that the presence of transgender students itself was a form of sex-based harassment that discriminated against the cisgender students. I see a lot of knowing nods on the screen because, of course, these are the same arguments that are being advanced in a variety of contexts today, including sports. But at the time, those claims were fairly novel. We were sort of astonished to see Title IX turn on its head. And for myself as a litigator, coming out of more of an employment background, I had always thought of Title IX doctrinally as a bit of a stepchild to Title VII. So of course, knew about its incredible impact in the athletic sphere on women and girls' lives. But as a matter of doctrine, sort of thought it was a bit of a Me Too sort of statute. There were more cases being litigated under Title VII. Standards were typically generated or became widespread in the Title VII context and then sort of filtered their way down to the Title IX context. And it's been such a delight as a litigator to learn how untrue that really is and to see how ahead of its time in some ways Title IX has been leapfrogging ahead of Title VII in many contexts and certainly developing its own case law that is protective of all forms of sex discrimination. In the Women's Rights Project, we work on a wide range of Title IX issues, including sexual harassment and assault, supporting the rights of all women and girls, cisgender and transgender, to participate equally in sports and other school programs, rebutting the notion that sexual harassment is somehow a protected form of free speech, and of course, combating student dress codes. I can't give up this moment in the spotlight without mentioning the terrific victory that my colleague Galen Sherwin won yesterday on behalf of charter school students in North Carolina who were forced to wear skirts in order to attend school. And yesterday, the full Fourth Circuit sitting en banc rejected the notion that public schools of any kind, whether charter schools or traditional public schools, can enforce gender stereotypes through a sex-specific dress code, like the requirement that girls wear skirts. And while the facts in our case were particularly egregious, with the founder describing girls as fragile vessels and admitting that the purpose of the policy was to promote chivalry, an idea that some of the dissenters picked up on with a sort of quaint nostalgia for the age of knighthood, a time that was actually quite violent for many women and girls. But I think the decision has really far-reaching implications, and is a terrific example of a place where, in the education context, we can help judges understand the many, many forms that sex-based discrimination can take, even before they necessarily have gotten there in the Title VII context or in other contexts. So very exciting to be developing this case law under Title IX.
Thank you, Ria. And finally, Shaheena.
Thanks so much, Amanda. First, let me say how honored I am to be on this panel with Nic and Shiwali and Ria to commemorate and to reflect on Title IX at 50. And I also want to thank the folks in the audience who are sharing this hour with us. In terms of my path to civil rights work and to Title IX issues more specifically, it was kind of winding, but before I joined the education section about 10 years ago, I worked in a different section of the Civil Rights Division called the Special Litigation Section. And that office handles, among a wide range of other issues, investigating law enforcement agencies for allegedly unconstitutional policing. And in one of those cases that I worked in the Special Litigation Section, I had the opportunity to develop DOJ's first ever investigative findings related to gender bias in policing by a law enforcement agency. And I will never forget conducting interviews and reviewing records in that case and seeing how they reflected such skepticism and such really deep-seated stereotypes about women that were coming to the police to report sexual violence, and really skepticism about their credibility and their worthiness of protection and effort and belief. And I think that really stayed with me throughout my time there, and I carried it into my work in the education section. And it has really informed the work that our staff has done around, or that I've done, and with our incredible staff around sexual violence and Title IX issues. Now, as chief of the Educational Opportunities Section, I have the great privilege to lead DOJ's work to protect students from all forms of discrimination in both K through 12 schools and higher education, sex discrimination, as well as discrimination based on race, color, national origin, religion, and disability. One of those statutes, of course, is Title IX, and our enforcement program focuses on recipients of financial assistance from DOJ, but is also significantly broader than that. And so we work to address all forms of sex discrimination, including sexual harassment and assault in schools, as I mentioned, but also harassment because someone does not conform to gender stereotypes, discrimination based on sexual orientation or gender identity, inequitable athletic participation, opportunities for students. And we do that work through investigations and compliance reviews, negotiating and monitoring Title IX settlement agreements, as well as filing amicus briefs in the appellate courts, and that's done by our appellate section, and statements of interest in federal district courts. I will also mention that we do this work in coordination with the Federal Coordination and Compliance Section, which is another section within the Civil Rights Division that AAG Clarke mentioned. And of course, in close coordination with other federal agencies, including the Department of Education. One example of that work is that EOS and FCS attorneys, and EOS is a shorthand for the Educational Opportunities Section. You may hear me say that. We work in a variety of Title IX interagency working groups, including a STEM working group in which federal agencies from across the government discuss Title IX policy and enforcement efforts. We have a campus sexual assault and domestic violence interagency working group where we can share insights and updates and information related to federal initiatives to combat sexual violence, domestic violence on college campuses. I would describe it as a very multifaceted approach to promote compliance with Title IX.
Thank you, Shaheena. And thank you all so much for sharing. It's really terrific to have panelists with such a variety of experiences and viewpoints that will make for a great discussion today. The next question is for Shiwali, Ria, and Nic. What would you identify as today's most pressing Title IX issue facing students, whether elementary and secondary or post-secondary? And Shiwali, why don't we start with you again?
There are a lot of issues that are facing students, but the two that I wanted to focus on for today's panel is sexual harassment of students, which continues to be pervasive, and the attacks against LGBTQI+ students, especially students who are trans and non-binary. So regarding sexual harassment in schools, it's extremely prevalent. There has been various surveys that have been done to document how prevalent it is. And so what we know is that about more than 1 in 5 girls from ages 14 to 18 report being kissed or touched without their consent. This trend continues into college. So for undergraduate college women, at least 1 in 5 to 1 in 4 have experienced sexual assault. And that number has been consistent through various surveys that have been out for decades. For transgender and gender nonconforming students in college, it's about 1 in 4 are sexually assaulted, and for students with disabilities are 2.9 times more likely than their peers to be sexually assaulted. So prevalence rates are really high, and unfortunately, too often these students are not being met with support, and as a result are unable to succeed in school, despite Title IX's promise to ensure that all students can succeed and would not experience discrimination based on sex, which requires schools to respond to sexual harassment. So, for example, 34%, so about a third of college student survivors of sexual assault drop out of college. And yet we've seen a weakening of civil rights protections for these students through decisions that have come out of the courts and regulatory changes, so changes made to the Title IX rule in 2020 under the Trump administration. So that's one issue that I wanted to talk about. And then the other concerns attacks against the rights of LGBTQI+ students who already experience such widespread discrimination, including high rates of harassment in school. And this year, I think many of us know and have been hearing about how there's been an unprecedented amount of state laws and policies targeting LGBTQI+ students, especially trans students, that are grossly inconsistent with Title IX by banning students from using school restrooms and participating in sports consistent with their gender identity, censoring discussion of their very existence, punishing adults who seek to protect their health and safety. And the violent rhetoric and threats and actions directed at them have just escalated. And yet with any developments that have come in the law or increased enforcement of protections for trans students, there's also been a backlash, often led by powerful and well-financed right-wing groups that oppose trans rights. And also a backlash by groups that oppose protections for student survivors who have been litigating in courts to chip away at their rights, have been advocating in states and with federal, state governments at the federal level to also chip away at their rights. So again, these are just two of the many issues, but the ones that I wanted to highlight in my remarks today.
Thank you, Shiwali. Nic, let's move on to you.
Yeah, so I would say that in my experience as a K through 12 student and advocate, the most pressing Title IX issue facing students in K through 12 schools is really a lack of comprehensive non-discrimination protections and lack of explicit language enumerating the rights of LGBTQ plus, specifically transgender students, as well as those who don't fall into either of the traditional genders, who might identify themselves as non-binary. Lack of protections for these groups has led to much ambiguity among schools and school officials regarding the extent to which school administrators and teachers are required to treat students according to their gender identities. And this can lead to a multitude of adverse situations in which students are not placed in facilities consistent with their gender identity or otherwise allowed specific resources to succeed, such as being assigned and treated with the correct gender-based pronouns. In my experience, for example, I've had numerous teachers who would not respect the pronouns of transgender students, and fears of looking overly litigious or going through the processes necessary to defend their rights, many of the students would simply tolerate it. I think that we can't truly uphold the promise of Title IX unless we fundamentally readjust our understanding of the various forms that gender discrimination can take, and that it doesn't always involve an initiation of violence, or it doesn't even have to always be explicit in nature, but it can also be the culmination of small microaggressive behaviors from people in power towards students that makes the educational environment fundamentally inhospitable. I also think that there is an exclusion of LGBTQ plus inclusive curriculum and sex ed within K through 12 schools, which goes again to the point I mentioned before of the lack of comprehensive protections for students, undermining the power that judicial decisions and precedent can have, as we've also seen with other civil rights issues recently.
Thank you, Nick. Ria, how about you? Most pressing Title IX issues today?
I have to say that Shiwali and Nick really have put their fingers on exactly what I would also identify as the most pressing issues. And I just have to say, I mean, it's such a delight to have Nick on this panel, and I really appreciate the focus on K through 12 education, particularly when it comes to sexual harassment and assault, an issue that I think is often associated with college campuses, despite the really alarming rates of sexual harassment and violence that we know occurs at the K through 12 level, as Shiwali described. Because we just got the decision in Peltier yesterday, I have to mention, I think, the role of dress codes as a common thread that actually runs across all of these issues. We know from some of the expert testimony in our case that schools that employ sex stereotype dress codes, like a requirement that girls wear skirts, are teaching students about what it means to be a boy, what it means to be a girl, how other students should be treated, increases actually rates of sexual harassment by boys who are in an environment where they're taught essentially that girls should be treated in a particular way at school and that their sex is relevant to how they learn. Judge Keenan also had a wonderful line in her opinion that I think bears repeating, which is about the impact on students, even on those students who seem to thrive. So we heard from Shiwali some of the really distressing statistics about students who drop out of school as a result of sexual harassment and assault, which is a major problem. But for all of the students who don't drop out, right, or who still manage to get good grades despite that, right, Judge Keenan says we don't know what those students might have been capable of had they not experienced the discrimination. And it's such a powerful context when you think about Title IX as being about every student having the full opportunity to succeed regardless of their sex. We don't know what some of these young people might have been capable of had they not been subjected to sex discrimination.
Yeah, powerful point and pressing issues, all of them. Shaheena, can you speak to what the Department of Justice is doing on some of the topics that the panelists just identified?
Yeah, I'm happy to do that. And thank you to the three of you for raising, like Amanda said, all such compelling issues. To start with, some of our work around sexual harassment, including sexual assault. The department has long been committed to enforcing Title IX in this context and to address schools' failures to respond promptly and equitably when they receive allegations of sexual harassment and sexual assault. I want to give you a couple of recent examples of some of our work. In September of 2021, we reached a really groundbreaking, there were a lot of firsts for the section in a resolution agreement that we reached with the San Jose State University in California to address violations of Title IX in this area. We worked really closely with partners in the U.S. Attorney's Office for the Northern District of California to investigate allegations related to SJSU's response to reports of sexual harassment and assault by an athletic trainer, a longtime athletic trainer in the sports program. And through that investigation, we found that for more than a decade, this trainer sexually harassed and assaulted student athletes at this school under the guise of something that he was calling trigger point therapy. And our team at DOJ confirmed that the university was on notice of these complaints dating back to 2009 and took completely inadequate steps to respond in a way that put additional students at risk. And we also found that the university retaliated against 2 employees at the university who spoke up and tried to stop this from happening. So the settlement agreement that we reached in September requires SJSU to make broad reforms to its Title IX practices, to invest in its Title IX office and provide student support services, conduct training and outreach. And the university was also required to pay $1.6 million in damages to survivors who participated with our investigation and who came forward. That was the largest damages payment in a Title IX matter that the section obtained so far. And in another first, we put together a plain language summary of the relief in this case so that students could really better understand their rights and the university's obligations under the settlement agreement. And that was something that we thought was really important and something that we are committed to doing more in these cases because of the importance of making sure that those that are the direct beneficiaries of this relief understand and are empowered to advocate for themselves as well. So that is one example. Before that, we had a Title IX settlement agreement the year before involving Utah State University. Amanda was one of the attorneys that worked on that case. And there we learned of allegations that USU did not respond to multiple reports of serious student-on-student sexual assault. A lot of it concentrated in the football program and in Greek life. And again, there we were able to obtain really significant relief for the students, and we are in active monitoring of that settlement agreement. So in addition to our own enforcement matters, as I mentioned earlier, we also do statements of interest. The appellate section does amicus briefs to try to help shape the law in this area. And I think Shiwali had mentioned some court decisions, recently, and we have been active in filing briefs in this area. I also want to mention that our appellate section filed an amicus brief in the case that Ria mentioned, the Peltier case involving the school dress codes. And this is again, appearance codes is a very important issue for us. In addition to that amicus brief, we had filed a statement of interest in a Title IX case involving, it was filed by the Legal Defense Fund involving the Barbers Hill School District in Texas. And that case really raises some interesting issues of intersectional discrimination. So in addition to sex discrimination, race discrimination is at issue in that case. And enforcement of appearance codes is one of the areas that we really see that issue of overlapping forms of discrimination, interacting to amplify the barriers that students are facing to access the educational program. So I will leave it at that.
Thank you, Shaheena. The next question is for Nic. Nic, I know you mentioned a lot of different things that K-12 schools are not doing very well with respect to Title IX. Do you think there are any areas where elementary and secondary schools are doing especially well in the Title IX field?
Yeah, so I would say that some areas in which K-12 schools are upholding the spirit of Title IX are in areas of curriculum and sports to a certain extent, but at the same time, it greatly benefits certain groups more than others, which is why I think that the conversation around equality versus equity is very important in this discussion. While certain groups have made advancements, these benefits have mostly been concentrated among cisgender women, but as this is still a marginalized group, I still think that this is a victory that Title IX can claim. It's almost unimaginable at my school to hear of a female student not being able to participate in sports if she wants to, as well as facing, a lack of representation within the curriculum, at least within the context of my school experience. I know that there has been a conscious effort among many school officials to increase the representation of topics involving women and women's history and women's issues within school curriculum. So I think that in those two specific areas, school officials have done especially well at advancing the promise of Title IX, but I would be remiss if I didn't also recognize that there is still a very long way to go in terms of groups who may not be in as privileged of a position as cisgender women students.
Definitely a good reminder of the progress we've made and the work yet to be done. Shiwali, similarly, you mentioned that while schools are addressing sexual harassment, oftentimes survivors are not receiving the types of supports that they need to continue their access to the education program. What sorts of supports do you think they should be getting?
Yeah, so this is a huge issue, and lately we've been hearing more and more about, from student survivors and advocates who work directly with survivors about how they're not having sufficient access to supportive measures after experiencing sexual harassment, including sexual assault, and also not having sufficient support or protections against experiencing retaliation. And so for supportive measures, having access to meaningful supportive measures is so critical to protecting a student's access to education. And schools fail to provide effective responses, and this could include, responses to support students in their healthcare needs, including mental health needs, counseling. It may include academic accommodations, so extensions on exams if a student needs some time in the aftermath of having experienced something so traumatic before conducting an exam, or extensions on homework assignments, classroom changes, so they're no longer in the same class as their assailant or their assailant's friends who might be harassing them, housing changes, no contact orders. There are really a variety of things and measures that schools should be considering in determining, what is needed to protect a student's access to education after experiencing harassment, and students should also understand that they have rights to these supports and how to access them. But unfortunately, that's often not the case. Earlier, Ria had mentioned that, in addition to so many students dropping out of school after experiencing harassment, there are other impacts that they experience. It could be being, experiencing lower grades in the wake of their trauma, or maybe they're doing well academically, but it's still, the trauma from having experienced the assault has created other mental health issues. And so, there are a lot of impacts, and that's why these supportive measures are so important. And then in regards to retaliation, far too many student survivors have been disciplined by their schools for violating a school rule during the incident, like a rule against drug or alcohol use. That's something I mentioned that we were seeing when I was in college that was happening against survivors a couple of decades ago. That's still happening now, or they're being punished for engaging in sexual activity or for engaging in some sort of, physical fighting when they were just defending themselves. Other students have been disciplined for missing school in the aftermath of harassment to avoid seeing the harasser, or for making an allegedly false report only because the school didn't find that the harassment occurred after their investigation. And so these responses are harmful because they only further silence survivors and deter students from reporting when this is already so underreported, yet so prevalent. And so schools need to have amnesty policies. They need to have policies that assure students that they will be protected from punishment, when they come forward with a report of harassment. It needs to be very clear. And, unfortunately, we've been hearing more and more about not only colleges and universities, but also K-12 schools who have been punishing students after coming forward just because they didn't believe them. The other issue in retaliation is an increase in retaliation from abusers who have been filing retaliatory Title IX cross complaints against their victims, or defamation suits or threats of defamation suits, which again just contributes to deterring survivors and coming forward. And, this all just shows to survivors that the cost of reporting is just too high to bear. So, when it comes to ensuring that survivors have access to the support that they need to feel safe and to succeed in school, really to fulfill Title IX's promise to ensure that students are not losing access to school, there needs to be improvements in the availability of supporting measures and students' awareness that they exist and are entitled to them, and also better protections against retaliation.
Thank you. Ria, my next question is for you. Nic mentioned that Title IX is known for good reason for its lasting impact on increasing the opportunities for women and girls to participate in athletics, but can you talk to us about Title IX's impact in lesser known areas?
Absolutely. I said at the top that one of the things that's been really delightful for me as a litigator is to realize the many ways in which Title IX has had an impact, not just on the lives of students, but really on the development of sex discrimination law far beyond the educational context. And I want to mention just a couple of those places. And the first is when it comes to students who are pregnant and parenting. The original Title IX implementing regulations, which were promulgated by what was then the Department of Health, Education, and Welfare in 1975, expressly specified that discrimination based on pregnancy, was a form of sex discrimination prohibited by Title IX. And, this was huge, both as a practical matter, as a doctrinal matter. At the time, it was common for schools to have policies. If a student was even suspected to be pregnant, students could be forced to take pregnancy tests. Students could be automatically expelled for being pregnant or sent on a course of home study, regardless of the student's wishes. But this is also in 1975, right? This is 1 year after the Supreme Court's 1974 decision in Geduldig, which, as folks know, is where the court said that discrimination based on pregnancy is not a form of sex discrimination under the Constitution's Equal Protection Clause. It is also, for 3 years before Congress passed the Pregnancy Discrimination Act in 1978, specifying that pregnancy discrimination is a form of sex discrimination in the workplace, which was itself a rebuke to yet another wrongly decided Supreme Court opinion in General Electric versus Gilbert. And I know we're here to talk about Title IX, but I think that context is so important to understand how the 1975 implementing regulations were in many ways ahead of their time. And we are still today sort of fighting battles that perhaps we thought had been resolved almost at the outset of Title IX. I think dress codes are another terrific example. The 1975 regulations expressly prohibited discrimination in codes of dress and appearance. And we saw the Reagan administration roll that back in 1982, rescinding the reg purportedly as a matter of enforcement priorities. And what we've been left with since 1982, I think, is real confusion in the courts about what that rescission meant, what kind of weight it should be given. We're thrilled to see the Fourth Circuit understand that the rescission was in fact simply a statement of enforcement priorities. It doesn't somehow take dress codes out of Title IX's ambit. It doesn't amount to a blanket exception, which is what the charter school had asked for. But at the same time, it's sort of astonishing to think that we're still litigating questions that might have been decided in 1975. And so we're delighted to see the department take this on as an enforcement priority. And, we'd love to see express guidance and regulations in this space as well to sort of conclusively answer that question that was, I think, intentionally left open by the Reagan administration in 1982. Just one other place where I think the original implementing regulations left us better off than we were today. And that's when it comes to single sex classes. So many people think about Title IX's role in sort of ending single sex schools, public schools, but not necessarily single sex classes, which were sort of few and far between as a result of Title IX, which sort of was intended to get at this issue of, boys being offered courses like shop and business, and girls being taught how to dress like ladies or being offered only home ec. We saw in 2006 another rollback, this time by the George W. Bush administration, in part funded through No Child Left Behind, which incentivized schools to create what are categorized as innovative, and I'm using scare quotes around the word innovative courses that can be taught in a sex segregated manner. And this has encouraged a proliferation of sex-specific programming, which is based essentially on the very same stereotypes that Title IX was intended to stamp out. So we've seen some rollback with guidance during the Obama administration to attempt to limit that, but this is another place where I think we could see a need for real regulatory action to get us back simply to where we were in 1975, and to make plain, at the end of the day, it's really impossible to design sex-specific programming without incorporating sex stereotypes, because we know from the science that our brains are not hardwired differently based on who we are. And what's especially tragic is these programs have been rolled out in large part to communities that have been failed by public schools as a panacea, particularly targeting Black boys. And I just want to make really clear, right? Our boys, I have one, right? Our boys deserve better than junk science. They deserve meaningful interventions, and it's distressing to see gender stereotypes trotted out in a sort of misguided effort to paper over race discrimination.
Thank you, Ria. Well, in the interest of time, I want to make sure we leave some time for audience questions. So I want to turn to those. And audience, once again, if you have questions, please feel free to put them in the Q&A feature on Zoom. Okay, so for our first audience question, as a former Title IX compliance officer, I found that ignorance of Title IX was rampant, and there was huge misunderstanding of what it required. That was 20 years ago, but I am not sure that has changed much. How important is it that we greatly expand professional development for all educators and to provide federal resources to support it? Would this help improve the very imperfect implementation of Title IX at age 50? And I'll leave that open for whichever panelist wants to answer. Nic, you got your hand up first.
Okay, so I would love to take that as a student in K through 12 education who has experienced teachers who have what I would label to be a lack of knowledge of Title IX provisions and professional development training to enforce them. I would say to the person that asked that question, absolutely, to all sections of the question. I think that it is very important that teachers receive greater training than they do currently on what the Title IX provisions mean, how to ensure that they are being upheld within educational spaces, and also to extend their idea of who is incorporated in those Title IX provisions. A lot of teachers in K through 12 schools throughout this nation simply don't know how to engage with LGBTQIA+ students, particularly transgender and non-binary students. To exemplify this, I have an experience where a teacher of mine expressed to me that when I had told them that I used the pronouns he and they, that they thought I was identifying as two people simultaneously. Now, while one might normally laugh this off as a display of ignorance, I saw it as an indicator that teachers are not getting sufficient knowledge and resources to understand what transgender and non-binary students are going through. And so I think that extended training in this regard will allow for an educational space that is more accommodating to people of all different backgrounds and identities, and reduce the extent to which students have to go to experiences such as the ones that I've endured.
Thank you, Nick. Does anybody else want to comment on that question? Okay, seeing no takers, we'll move on to the next one. A member of the audience says, I would love to have the panelists discuss how to understand Title IX within an intersectional framework. Even though Title IX is limited in its frame, how can we be aware of the reality that folks experience harassment and violence based on the unique intersection of multiple identities? And how should this inform our work?
Okay. Oh, God, yeah.
I'm happy to start, Shiwali. I'm curious to hear what you were going to say. I love this question, and I think the answer starts with, right, expressly recognizing intersectional discrimination as not simply the sum of its parts or an overlapping Venn diagram, but rather a form of discrimination that perpetuates distinct stereotypes that happen at the intersection of multiple identities. And as Shiwali mentioned earlier, Black girls in particular are often stereotyped, perceived to be more adult as they are, what we call adultification, more often subject to dress code violations because of perceived adultification or perceived sexuality that adults project onto young Black girls, are more often punished when they themselves report sexual harassment and assault based on stereotypes about promiscuity or about credibility. And so, all of these things don't happen just because the student is Black or just because she's a girl. There are stereotypes that are specific to Black women. And of course, the same is true for so many other overlapping identities. And this is another place I have to say where I see an opportunity for the department to lead in terms of providing guidance on how to think about intersectional claims and to make plain that survivors don't have to plead a sort of magic set of comparators in order to be able to prove that discrimination of this kind is prohibited by Title IX.
Sorry, you were first.
I was just going to add, I definitely agree. I think kind of just talking about it and raising awareness of what intersectional discrimination looks like, and really speak to the experiences of so many students who are experiencing discrimination, not only based on their gender, but also their gender, race, or disability, or a combination of other factors. And I think naming it and having students' experiences be seen and understood by, the government and policymakers is really important. And, I also think that this also requires that there be some consistency in the standards, so for example, with sexual harassment, before the Title IX rule changes were made in 2020 under the Trump administration, there were consistent standards that the Department of Education and Justice applied for harassment based on race, color, national origin, disability, and sex, right? There was guidance that came out in 2010 that addressed these standards. But now, because of the changes that were made in 2020, the harassment that someone experiences as sexual has to be more severe and pervasive and objectively offensive. The notice standards are more narrow so that, schools are on the hook only when a certain subset of employees know about it. Schools would be on the hook if they were clearly unreasonable rather than be unreasonable. And the reality is that for students who are experiencing multiple forms of discrimination and harassment, it's not siloed like that. If it's sexual and it's also racialized, to have a student have to be subjected to two different processes and standards, it just doesn't make sense, and it causes a lot of confusion. So I think one area where we could and do need improvement is to ensure that there's more consistency so that when students are experiencing multiple forms of discrimination, they're not held to different types of standards.
Great. Shaheena, did you have more to add?
Sure. I also love this question, and I loved all the responses as well. I think there certainly has been deepening awareness for us that, as Shiwali said, that this is not siloed bases, that these, when there are multiple forms of discrimination that a student is experiencing, that they act together to amplify and to, compound the obstacles that student is facing to access the educational program. And so that is absolutely something, where there is a deepening awareness and also a real focus in terms of our enforcement. I mentioned the Barbers Hill Statement of Interest. We also filed the Statement of Interest last year in a Title IX matter where the student was a student with a disability and was nonverbal. And so, looking at being able to weigh in on that case and to explain the way that overlapping forms of discrimination have affected that student and led to, what happened to her and magnified the failures of the school district's response, I think was really important for us. I also, wanted to note that I think we're, really fortunate in EOS in that our jurisdiction is very broad. And so in addition to Title IX, we also enforce Title IV of the Civil Rights Act of 1964, which prohibits not only sex discrimination in public schools, but also discrimination based on race, color, national origin, and religion. And of course, we also enforce Title II of the ADA, which protects students from discrimination based on disability. And so we do, we are expanding our focus very intentionally to be able to maximize our use of statutes to kind of address the whole problem and to address, what's being faced by the whole student.
Nick, go ahead.
Yeah, so I would say first I want to amplify the point about intersectionality, not just being an analysis of siloed identities. I'm reminded of a quote from an author whose name I'm forgetting, where they said, acknowledging that people can be Black and women and gay at the same time is not intersectionality, that's common sense. But intersectionality as an analytical framework instead requires us to analyze the unique and interdependent systems of oppression that create unique experiences of discrimination and disadvantages for some populations over others. And I'm reminded of my experience navigating the education system as I did these past 12 years as a working class Black and LGBTQ plus student, and how I experienced things that peers who may have been Black or LGBTQ plus or working class individually did not. And so I think when we talk about intersectionality as it applies to the framework of Title IX and gender justice in general, it's important for us to look at our policies, practices, institutions, and systems within education in ways that we may not traditionally see. Gender discrimination can take a variety of forms, and some legislative frameworks that reinforce and perpetuate gender injustice don't even have to mention gender themselves. I'm reminded, for example, of a fight within various counties in my state to get free access to menstrual products within school nursing offices within K-12 schools throughout the state of Maryland. And while at first glance, this may not seem like an issue that is explicitly based in class discrimination or gender discrimination alone, when incorporating them together, it becomes obvious that not having access to this resource within schools presents a barrier for lower class female students that lower class male students would not have to endure, nor wealthy female students would have to endure. So I think we really need to expand our understanding of intersectionality, and as it applies to Title IX, use the provisions of Title IX to fight for issues that improve the experience of people whose other marginalized identities may intensify the experience of discrimination that they face for their gender.
Thank you all for those comprehensive responses. Now, we've gotten a ton of great audience questions. I think we have time for just one more before we move on to final reflections. A member of the audience asks whether the panel can comment on sex discrimination against employees, faculty, and staff in higher education and how Title IX relates to that.
I'm happy to go first. I mean, obviously Title IX is an additional source of protection for these folks who may also be protected, by Title VII. Unfortunately, I think we're seeing some restrictions in the remedies that are available under Title IX that don't necessarily apply to Title VII. So for example, in the recent Supreme Court decision in Cummings suggesting that spending clause statutes like Title IX, don't provide for compensatory damages for emotional distress. So I think that the availability of Title IX in some ways the remedies may not be as robust. On the other hand, as I sort of started out, there are ways in which courts under Title IX have actually leapfrogged ahead of courts on Title VII, and dress codes are certainly an example of that. We still see many federal courts following the erroneous reasoning of the Ninth Circuit and Jesperson, which had upheld a casino policy requiring women and only women to wear makeup in order to work on the gaming floor, on the theory that men were also subject to dress code requirements. We see in Peltier a real rejection of that reasoning. And it's exciting to think about how not only students, but actually employees of educational institutions could use that decision as leverage to end these kinds of sex stereotyped requirements based on the notion that if we discriminate against everyone, somehow that amounts to discrimination against no one.
Anyone else like to weigh in before we move on? Okay, great. Now, as we start to close our program, we'd like to give all of the panelists a chance to share final reflections on Title IX's milestone anniversary. So for each of you, what would you ask the members of today's audience to do to help promote the goal of gender equity in education? And Shiwali, I'll start with you.
Sure. I think coming to this event is a start, just raising your awareness about Title IX. That was an issue that had come up earlier. There was a question asked about how, even though decades have passed since Title IX was enacted, there's still such a lack of understanding of Title IX. And, while the question's focus was on schools, I believe we're all impacted by it, right? Like employees are covered. If you have students who you care about or in your family, they're impacted by it. And so I think just understanding Title IX more is a huge step, and understanding that it's a very broad civil rights law. It's only 37 words long, but I think you've learned from this discussion, it covers a lot of protections, a lot of issues. And earlier I'd mentioned the 2020 Title IX regulations that was issued under the Trump administration, and how those protections, but I didn't go into detail, but the protections significantly weakened, the rules significantly weakened protections addressing sexual harassment in schools. And the Biden administration has indicated last year that they were reviewing the rule. We know that we are expecting a proposed rule to come out. And once a proposed rule, which is the Department of Education's proposal for how to change a Title IX rule, comes out, there's an opportunity for everyone to weigh in and to submit comments during a specific time frame. I don't know if it'll be a month, 2 months, 3 months, but I think that is a really great opportunity to talk about all of these issues that have come up, harassment, LGBTQI+ protections, dress codes. Ria mentioned earlier that she would love to, and I would agree, to see guidance, explicit guidance, regulation addressing dress codes. So that is one opportunity that should be coming up hopefully soon.
Nic, would you like to go next?
Yeah, so I think as far as reflecting on Title IX goes, Title IX has been a very consequential piece of legislation that has, without a doubt, advanced the opportunities and living standards of many people in this nation. But as I mentioned before, a lot of these benefits have unfortunately still been concentrated within particular groups over others, as historic and even contemporary ambiguity as to who is covered by Title IX have made systemic queer and transphobia able to run rampant through educational facilities. I think that one way that members of today's audience and beyond can promote the goal of gender equity in education and thus advance the promise of Title IX is by empowering youth. Youth are not only the future, we are the present. And I think that it's important that we be able to access the resources, conversations, and advocacy spaces that many adults have taken over. I think that we should be empowering youth to understand their Title IX rights using age-specific language that is comprehensible to them. It should be given to them in school curriculums an understanding of Title IX, as well as what their specific rights under the legislation are. I also think that student voices need to be amplified. Students are not silent. We are unfortunately silenced by a lot of adults who don't necessarily see our voices as being important in this conversation. So I think that more conversations and listening sessions like this with representatives of the Department of Education and Department of Justice need to be had with panels that incorporate a broad array of students and student voices from different experiences. As I've tried to hold my own here, I'm still reminded that I am one of 4 million students graduating high school this year, and therefore it's impossible for me to represent the unique experiences of every single student. But with broader populations of students being involved in these types of conversations, we can more accurately approximate the issues affecting populations across this country. I want to close with this thought. It's estimated that over 2 million youth in the United States are LGBTQ+, and that another 200,000 youth are transgender, numbers that will only increase as social stigmatization of these populations decreases, encouraging more people to disclose or come out with their LGBTQIA+ identities. LGBTQ+ students have the same innate potential to thrive as other youth of different sexualities and gender identities, but many of us are withheld from this potential due to discrimination and hostile climates. These disparities are intensified by the identification at the intersections of race, disability, class, indigeneity, and many other identities. Schools and school officials and government officials are all responsible for not only intervening in bullying, harassment, and intimidation, but ensuring that policies, practices, institutions, and systems do not discriminate against LGBTQIA+ students, and taking proactive steps to address these educational inequities for a better future for all of America's children. Thank you for having me today.
Thank you, Nick. Ria?
You certainly have held your own today, Nick, and I think it was a bit unfair of Amanda to ask me to follow that. I kind of want to close this out here. I'll just make 2 quick observations, and one is just to remember what a transformative promise Title IX was and continues to be, right? The notion that sex is irrelevant to how we learn or should be irrelevant to how we learn and to our opportunities to succeed at school was and is a radical idea. I think about this often as I, watched children line up as boys and girls to go to recess or to go to lunch or to access the water fountain, or you walk past older school buildings that still have separate entrances labeled for boys and girls, right? We see those reminders and we think of them as a thing of the past, but in reality, too many of our public schools still infuse gender throughout the day and make sex relevant to our children in a way that it should not be. And so it's on each of us to sort of hold that promise. What would it mean to treat gender as irrelevant to our children's ability to learn? What would it mean to live each day as though that were true? How would we conduct ourselves differently? How would we treat our children differently? How would we dress differently? How would we walk through the world differently? And to try and make that promise a reality for ourselves. The second piece is just to really avoid the pitfall of pitting students against other students. We've seen today so many examples of how Title IX has been weaponized to pit cisgender students against transgender students, to pit students who report sexual violence against students who are calling for fair process in school discipline proceedings. The reality is that Title IX is not about pitting students against students. It's about holding schools accountable to make sure that every student every individual student has the opportunity to succeed regardless of their sex. And we really have to resist this idea that somehow there's a limited supply of equality to go around. We don't have a scarcity of opportunity, and we have to avoid the impulse to attack each other, and remember instead to celebrate each other and lift each other up, and to keep the accountability not on other students who are also trying to learn, but on the institutions that all too often have failed them.
An excellent message. Shaheena, would you like to close us out on this question?
Sure, thank you so much. And I actually want to respond directly to some things that Nic said, because so much of it resonated so powerfully for me, and really do, align with a lot of things that we've been reflecting on here in the Civil Rights Division and in my office. Nic, I think there is no doubt that we need to do a better job in government of engaging with the public that we serve, and in particular on this issue with the young people who are, the direct and the immediate beneficiaries of Title IX. And we really need to be intentional about thinking about the experience that we want people to have when they are interacting with the Civil Rights Division about these most, personal and difficult issues, and seeking to vindicate their rights. And we want to hear from the public and the people we serve about their lived experiences, and make sure that that is informing the work that we do. So I do think that that is something that we want to be intentional and thoughtful about. And I'm so happy to have had you in particular, but really all of these co-panelists, for this past hour. And I think we also need to be intentional about reaching people in formats and using language that is accessible and that is understandable. And that is not something that we have always done well, but it is critically important, because we share that goal of empowering youth, again, and empowering the people who are, to be benefiting from these protections. And so in terms of, what I hope people in the audience will do, I guess I would ask you to hold us accountable to those goals, and to, continue to engage with us, to submit complaints through our citizen complaint portal when needed, and to share that information with others. But I hope that this is, this is one of, many continuing conversations. So thank you.
Thank you. Ria, Nic, Shiwali, Shaheena, members of our audience, thank you all again for taking the time to be with us today to celebrate Title IX at 50, to reflect on the great successes Title IX has ushered in, and to look forward to what the next 50 years has in store.